Oh, no, it isn't. There it is. I will call this meeting of the Wausau Ethics Board to order. Thank you, Attorney Erlinson. And one moment, please. Will the clerk please call the roll?
Dexter,
Here.
Osler, DeVos, Kearns.
Thank you. And we, as usual, welcome members of the public and the news media who are here in attendance to observe the operation of the Wausau Ethics Code process. Also, I'd like to note the appearance of Ethics Board Legal Counsel, Attorney Eric Larson, and Respondents Legal Counsel, Andrew Erlinson, who are attending by video conference. Do we have Attorney Larson hooked up yet, Cody? Oh, there, I see him. All right, thank you. The first item on the agenda is review and discussion of and possible action on responses to the board's order for additional investigation dated July 1 of 2025 regarding the pending complaint filed against Mayor Doug Dinney. That meeting was held on June 30th, that last meeting. At that meeting, the board voted to conduct further investigation by sending orders to an additional 12 people, some suggested by the city attorney, and others identified in material sent earlier to the board by the respondent. The deadline for these 12 people to respond to our orders was July 22nd. Having passed that deadline, we have received responses from 7 subjects. The responses were included in the board packet for this meeting. 5 subjects gave no response at all. 2 subjects gave nearly identical responses, apparently with the advice of legal counsel, at least that's my assumption, saying that they were, quote, not comfortable, close quote, responding to the request, which was characterized as, quote, overly generalized, vague, and ambiguous, but stating they would be happy or willing to answer specific questions in writing or in person. Just like to make a couple of observations about that response that we received. What the subjects of this additional investigation received from the board were not, quote unquote, requests. They were orders issued by the Wausau Ethics Board and sent to municipal officers and employees. I'd also like to note that 5 subjects with their responses seemed to have no difficulty understanding what the board asked for, and they provided responses accordingly. And finally, I would note in connection with the willingness to answer questions that, of course, the board, if it so chooses, may subpoena any subjects who failed or refused to respond to appear in person at the hearing to answer questions under oath. Now, we turn to discussion of the responses that we did receive. Anything from the board about those responses? Is there anything that stands out to anyone here? I just noted that there were people who did not give any response of any kind. They were the Deputy Police Chief Todd Baton, Finance Director Marianne Grote, Facilities Manager Leo Gao, Consulting IT Director Gerard Klein, and Contractor Kyle Osmitz. They provided no response of any kind. The Fire Chief and the Deputy Fire Chief both responded that they had no contacts that were described in our orders.
I think on the question of a lack of specificity with looking like I think was...
We need your microphone on.
Can you hear me?
Now, yeah, that's good. Thank you.
So I think on the question of a lack of specificity when it comes to the general question The two responses that we got from both the Wausau Police Department and from Eric, I think those, in reality, if they need us to ask more specific questions, then we maybe need to revisit some, maybe corroborating some of the other testimony or statements that have been given. But I'm not sure what they're asking for, or I'm not sure they understood our request in general, if we were just asking for all correspondence. So that was my thought, is that if they need more specificity, we can ask more specific questions, but that's like asking us to ask a question by asking a question.
Yeah. And I guess I wonder, do they really need more specificity? Like I said before, we had a number of people who responded, didn't seem to have a problem with lack of specificity. Maybe they're just trying to be very careful. Another route we could go, I think, would be simply to subpoena them to attend the hearing and give testimony at that time. And then we could do it question by question, and hopefully that would resolve whatever problem they have. I think that the responses we received in this additional investigation did to some extent supplement what we had previously been provided. However, I don't think I saw anything that, to me, indicated that there was any real challenge to the facts that have been presented so far. So it's, to that extent, I'm wondering if we should be looking at this time, just a motion to close the investigation and plan on, if there's more we want to hear from witnesses, to do it at the hearing by, issuing subpoenas to attend the hearing. I don't know how the rest of you feel about that.
Yeah.
I would agree, just giving our short status right now on wanting to move that forward, to just close the investigation and continue with that subpoena at the hearing date.
Yeah, I think at some point, the board needs to decide that other than testimony at the hearing, we've heard enough. And I'm feeling like we've reached that point right now. Anything from Jesse or?
Did you make a motion?
I did not make a motion.
We don't have a motion yet, but
I'll
would you?
make that motion.
Doug is making that motion to
Whatever he said.
motion
You
to
have to
close
turn on
the.
your microphone and move a little closer.
Okay. I really have to get up here?
I know.
Got to
that's
stay
same.
close, yeah.
I really don't like it that much.
Yeah. So I take that as a motion to close the board's investigation into the ethics complaint filed against Mayor Doug Dinny. Is there a second to that motion?
I would second that motion.
Been moved and seconded. Any further discussion about that motion? Seeing none, we'll bring it to a vote. All those in favor of the motion, please raise your hand. It passes unanimously. The next item on the agenda, discussion of and possible action on scheduling regarding the pending complaint filed against Mayor Doug Dinny, including setting the next meeting date for the Ethics Board. First, I just want to express my gratitude to the board's legal counsel, Attorney Eric Larson, for his work in developing this proposed scheduling order and for discussing that proposal with the other attorneys. The proposed order seems designed to work with the hearing date of August 25th set at our last meeting, and I think that's laudable. We still want to try and get things finished as of that date. And the proposed scheduling order also anticipates 2 additional meetings of the board. One would be on or about August 8th to make a ruling on the respondent's motion to compel the depositions of the city attorney and the city clerk. The other would be to rule on any pre-hearing motions that might be made, and assuming such motions are made, that hearing would be between August 20th and August 25th. If we vote to adopt the proposed scheduling order, I believe we should be setting those additional meeting dates so they can be in the order itself. Is there any objection by any of the board members to trying to schedule those meetings at this time?
When you refer to the scheduling order, are you just referring to the proposal that we received in this email chain?
That's correct. Thank you for clarifying that, yeah. It's in the board packet.
Yeah.
Should be in the board packet, yeah, and it was sent by email.
And it had some dates that have, just one date that has passed.
By 18th?
Yeah, but that was for the motion to be made.
Okay.
I kind of, when I first read it, it jumped out at me that it had already passed, but
Okay.
the motion has been made,
Okay,
and and it was made by the 18th.
okay. Thank you for clarifying.
Sure.
Yeah, that was odd.
Yes, I think it would be appropriate to schedule.
Shall we try and do that for the August 8th meeting? Well, August 8th, on or about August 8th. Personally, I like August 8th quite a bit myself.
I have the latter part of the days available.
It's available for me.
So where are we on this list? I mean, this.
Ethics Board would meet on August 8th or such other date.
As determined.
So that's to make a decision on the respondent's motion to compel. Yeah, we want to make sure we're clear on this.
How late in the day? I did have that date scheduled for out of town, but
Could we do 4 PM that day, or is that too late?
on August 8th?
Yep.
No, I could not do that.
Couldn't do 4
Not
p.m.
that late.
What about the 7th? That'd be better for you?
Oh, yeah, I could do the 7th if it's after 4.
Yeah, we could do
Or
4 or
after.
5 o'clock.
Or after would work for you on the 7th?
5 o'clock would be preferable for me, but
I could do 5.
And Doug?
To look at my calendar, is it August?
7th.
Okay. Not
That would be a Thursday, correct?
Correct.
Thursday. Depends on the time. I'm supposed to be somewhere by 6 p.m.
Could we try and do it at 4?
Or 4:30.
4:30
Do
would
it
be
4:30?
great, actually.
4:30. If I can leave by 6 or before 6, that'd be okay.
You'll keep us honest, Doug, and get us out of here.
That sounds pretty good, but now we need
August 7th, 4 o'clock,
4:30.
4:30, and then I can leave at 5:45.
Sounds perfect to me.
That's okay? 'Cause it really should be elsewhere.
Well-
Good thing I got this.
I mean, that meeting doesn't have to be strictly only about the motion to compel. And I'm thinking we might use some of that time to look at, to start talking seriously about maybe actually decide who we want to subpoena to be at the hearing.
I would agree with that.
We need to do it, by about that time.
Yeah.
But we don't need to be spending a lot of time on a lot of other things, in my opinion. I think if we can look at those two things.
But we should come prepared to deliberate on who we want to subpoena at the time?
Right,
Perfect.
and we should be thinking about it in the meantime. I'm sure you already have been giving it some thought, but we should be talking about it at that meeting. Now, we need to check with Cody and with the attorneys, both Attorney Larson and Attorney Erlinson, about availability for August 7th at 4:30. Let's start with Cody. We have,
And the council chambers is available, and I would be too.
all right, thank you. Attorney Larson?
I am available, yes.
Okay.
I would probably be remote on this, so.
All right, I think that would be okay. Attorney Erlinson? Can you hear it? Can you hear
I'm
me?
available. Yep.
You're
I
available?
can. Sorry, I was unmuting. Yeah, I'm available at 4:30 on the 7th. Thank you.
Okay, thank you. Yeah, and I was not talking into the mic, so I've got to watch that. All right, it looks like August 7th at 4:30, the next meeting of the Ethics Board, and we will be making a decision on the respondent's motion to compel depositions by the city attorney and the city clerk. Now let's turn to trying to reserve a date and time for that last meeting right before the hearing is scheduled. And that would be on ruling on any pre-hearing motions. Actually, I think the proposed scheduling order says pre-trial motions. I'd like to change that terminology to pre-hearing motions that might be made. And it looks like the time period during which we can try and work out a meeting would be August 20th through August 24th, with the hearing on the 25th. Anyone have?
I have a conflict. I am out of town starting on the 18th. I could be back in by Friday. My plans are not set in stone right now. But I could be back the 22nd. It would just be the time before. Otherwise, we could look at ruling on any of those. I don't know if it's too late to rule right before the hearing.
What was it you said about the 22nd?
I could be back in town by the 22nd.
Okay. I'm available that entire period. I see Jesse.
I could do the latter half of that day, yep.
Okay, you were talking about the 22nd.
Mm-hmm. That's a Friday.
That's
And Doug?
22nd?
Yeah.
Yeah, I'm available, and that's for scheduling the hearing, or that's,
That's for
The hearing.
dealing with any pre-hearing motions that might be
Okay.
made.
okay.
Would we think that that would just be the standard hour, or are we going to need more time than that for that one?
Is this again 4 o'clock, say?
Yeah, I'm thinking 4 o'clock unless that doesn't work for
That should be fine.
somebody. And, yeah, I guess we could ask Attorney Larson if he thinks an hour will be enough time to cover such motions.
It's difficult to know, though I will say that when I spoke with counsel, they were not anticipating making pretrial or pre-hearing motions. So, moot. This is just in the event we will get pre-hearing motions, we want to have a process. And so I think an assumption of an hour is probably going to be adequate.
Thank you.
I just kind of going back to my vacation I was scheduled. I do need to schedule that vacation. And so I'd rather not have to come back to Wausau. I'll be in Michigan. So I'd rather not come back if there's no hearing scheduled. I'm just wondering, I'm just trying to think out loud as to be creative as to whether that needs to be scheduled. If we don't know whether we're going to get motions or not.
Right. I think it's more that we're reserving time. I'm sorry.
I would suggest that the likelihood of a pretrial motion in light of our call and the events since, it's probably better now than it was when Mr. Larson and I previously talked about that issue. So I mean, I think there's a much better than 50% chance that some form of pretrial motion will be filed.
Okay, thank you. That's fine then. So scheduling August 22nd at 4.
All right.
The other thing I would point out is we will know as of August 9th because those motions need to be made by August 8th.
Okay,
So I don't know if that helps you with your scheduling, but
thank you.
All right. Next, I think we need to check with Cody.
The council chambers will be available. I will not, however. Both the clerk and I will be at our clerk's conference for that whole week. So you're welcome to have the meeting without me with an alternative clerk.
If
Okay.
they're due by August 8th, is there any reason why we can't? Oh, no, but the reply is due August 20th. I apologize. Never mind.
Okay. So we would have to have somebody else take on the clerking duties. But I'm assuming we can get somebody from the clerk's office that might be available to handle that. Is that, or am I assuming too
Certainly
much?
Try.
Pardon me? We can try?
Try.
What are your thoughts about the possibility of our success?
I have no idea.
Okay.
So would we want to schedule that with a tentative response from Cody saying I mean, obviously we need someone to help us conduct the meeting, so would we need to potentially change that date, or if we couldn't get a fill-in for Cody?
Well, I think what we'd be looking for would be somebody who can check schedules, take notes. I could even call the roll if necessary at the beginning of the meeting. So I think we could probably manage this, but we'll have to make sure that we do have something.
Could we do a recording for the minutes?
That's always done anyway.
That would be permissible.
Okay.
We should really have, we need to have a clerk.
Okay.
I mean, for many reasons, to manage the Zoom and, take the notes, and we should have a clerk.
And I would agree with that.
Cody, would you be able to investigate what's possible from your department? Okay. And what was your response, Cody, on the availability of the?
The council chambers would be available.
It is available, okay. And I guess we still need to hear from the two attorneys, Attorney Larson.
Well, I'm on vacation that whole week as well, but I can be available by Zoom. I would just say, one other option would be the 25th before the time set for the hearing. We could rule on the motions before we go to
On the date of the
that
hearing.
might.
Yeah, I don't mind
But
that
keep in mind,
process.
it is the day. It's the day before the hearing that we're talking about, and
Having a little trouble hearing you.
sorry. If it would be the 22nd, that's the last day before the hearing. And so I don't know how different it would be to be on the morning of the 25th, which is the day of the hearing, but it's, in terms of actual work time, it's essentially the same.
I would agree with that, but maybe it's for selfish reasons because I wanted to go on that vacation and I can't appear by Zoom here, so.
Well, if that's, I don't have a problem with that. And if Attorney Larson can foresee us being able to accomplish that, I don't know if you were suggesting some time just before the hearing or in the morning before the hearing. I guess I wasn't clear on whether you had a preference.
Well, I for example, we could rule on the motions at 8 in the morning, start at noon. I'm just throwing out ideas. It does have the complication of we're going to be subpoenaing a lot of people who will presumably be there. Depending on what these motions are and how we rule, they may not need to be there. But that would happen if we did it on Friday, probably anyway.
So realistically, if an individual were to attend on Monday and not need to be here, say it when they showed up, we would just acknowledge that at the time of the meeting or at the time of the hearing? Because how else would we communicate that to them if we were to meet on Friday?
Well, I think we can just cancel the subpoenas regardless.
Right.
And they have a few hours of knowledge of the cancellation, but that happens when you're in court all the time.
Yeah.
Yeah, that's my question. If it's not going to get in the way of anything, I'm amenable to doing it on Monday morning and then having that break between and then having the hearing be earlier in the day if that's better for everyone. My only concern would be the people we're subpoenaing at that point may or may not be able to accommodate us if we have it at noon.
Well, the subpoenas would already be issued, so they're just we're just canceling the subpoenas.
Yeah, that I
Telling
got.
them
I was
they're
just
they're relieved from
Responding
there.
more to the time
Okay.
when we're going to have it. Like, not that we have to make it convenient for those individuals we're subpoenaing, but I think that it's probably better if we do.
It's nice if we can, yes.
Yeah.
But we are dealing with a pretty short time frame here to work in, especially when, it's a busy summertime, people do have vacations. And I think the main thing is that we should reserve some time for those for rulings on those motions.
So should we move that?
You know,
to-
a third,
Yes,
as long as we're talking about scheduling, I think, to look at all issues, it would be possible to, if we have motions, to use that 25th to hear the motions and set the hearing at a later date.
I agree, and I thought that at the outset, but I wasn't sure if we could move that hearing date. But if we can, I think it would be better to have the motions heard and then have the hearing the next day or later. But I guess that if
Yeah,
that's
we
a
could-
problem.
I believe we could continue the hearing to a later date. Not anxious to do that, but, we are dealing with a very tight time frame here, and it seems like that could be a reasonable thing to do. Thing is, if we're going to be issuing subpoenas early in the month for the 25th, and then we change it, we may have to give enough time for new subpoenas. We can't just do it a couple of days later, I don't think, without having some real problems with witnesses appearing. So that could extend things by a few weeks, I would think.
Part of it is whether the respondent would object to that. One reason for trying to be prompt is to reach an endpoint. And so they're hearing the respondent's position.
Still having some trouble hearing you, Attorney Larson.
I'm sorry. I would be interested in hearing the respondent's counsel's thoughts on that.
Well, I would start by saying that some of the frustration, disappointment, and difficulty here is the fact that the complainants have not participated in this process in any meaningful way. It's not clear what intention they have, if any, to show up to actually prosecute their complaint. I don't believe that this board should be unilaterally deciding to issue subpoenas to witnesses when no one has asked for it. And who's going to question them?
Well, Attorney
I
Erlandson,
mean, this.
Let's stay focused on the schedule. Can we, I understand that argument, but our agenda item is the scheduling.
Right. And we don't have any input from the complainants. And that's a problem. And in terms of inconveniencing people that no one has actually asked to be subpoenaed, I don't know what to do with that. The process of this has been problematic. I want to have the opportunity to get it right. If the pre-hearing motions cannot be ruled on timely and have a hearing, yes, that's the product of summer and vacations, and everybody should take them. That's the reality we're in. But I certainly would not want to have pretrial rulings and then have months and months of additional process.
thank you. Well, board members?
Well, I do agree that I wouldn't want to extend it months and months for sure. That if we would move the hearing date, it would be nice if we did that very, very promptly. And if it is into the early September, then most people, we're back to school, we're back to our schedules, and should not have as much of a problem with vacations interrupting that.
Couldn't we just move it to later in that week? Or are we looking for a longer period of time than that? Because, I mean, really, it's just a matter of having them stacked on the same day that I thought was a little bit questionable. I think if we can get it resolved and then have the subpoenas to have a hearing maybe even Wednesday or Thursday that week, that still gives us the space between the two actions, right?
Yeah, and I think if we do it today, then, you know, when the subpoenas aren't drafted yet. So once we make a decision about when the hearing is going to occur, you know, we put that date in the subpoenas. So I guess I don't have a problem with looking at early September, you know, continuing the hearing date to early September.
Sure.
In order to accommodate a number of schedules and other things that have to take place. A suggestion from somebody on a early September date, if that's where we're headed?
I could make anything work the week of September 2nd. I could move anything around. There's plenty of notice to do that. It would, obviously, Monday is a Labor Day, so starting on the Tuesday, the 2nd.
All right. Have we made it, have we kind of come to a consensus yet on when we would have the hearing on the motions? Is that the April?
I would like it August 25th.
Yeah,
August
let's move that to
22nd.
Monday.
Okay.
For both Attorney Larson and for Robin.
And then we're talking about a hearing date of the first week in September, right?
Yep.
Specific request for a particular day in that week?
The 2nd would work. That's that Tuesday, the day after Labor Day.
I would have to interject that the only day that the council open is, that the council chambers are open all day is Friday. Otherwise, there's something going on in the council chambers every day that week except for Friday.
Yeah, and for a hearing, I don't see any way we can do it anywhere other than here in this room.
Correct.
Friday is what number? What day?
September 5th.
Would that work for the other board members?
That works for me.
Jesse's okay with that, and Doug?
I can't find it. It's not. Okay, I'm gonna try it again. Come on. Jesus Christ. Engagement, spider, right. Looks pretty open.
Okay, that works for me. So Friday, the 5th,
September 5th.
September 5th. Now we need to talk about a time.
Should we check with council as to their schedules on the 5th?
Yeah, we'll need to hear from them, and Cody's already told us. All right, Attorney Erlinson, you've got the large screen that we're looking at right now, so I'll start with you.
I'm available, freely available.
And Attorney Larson.
I'm available.
So then the time that this room is open, Cody, you said was it the entire day or was it?
That's correct, the whole day.
Okay.
Then the question becomes, how much time are we able to devote to this? And it seems like there's certainly the possibility, especially if there's no agreed statement of facts, that this could be a very long hearing. We might want to have pretty much the whole day available. If we don't need to use it all, that, you know, it's not the worst thing in the world either, but we want to have the time if we need the time. How early could we start? Are we talking about like 9 o'clock?
Do you think 10 o'clock would be too late?
Not if we go into the afternoon,
10 o'clock would be better for me if we could do that.
10 o'clock.
Sure. September 5th, Friday. Hearing. Okay.
And can we reserve it for the rest of the day, Cody?
Do we need a motion to continue the hearing date?
Yeah, I think we do need that, and then we can insert these dates and times into that proposed order, and then we'll need to vote on that as well. But I think that's a good point, Robin. We should vote on continuing the hearing date. The chair will entertain a motion to do just that.
I would move to continue our hearing date from our original, I'm going to forget our original.
25th, yeah, August 25th.
But we had a certain amount of days that we were going to hear it within.
Oh, beyond the
right,
120 days.
120 days, so that we're continuing that until September 5th.
September 5th, yeah. Is there a second to that motion?
Yes.
It's been moved and seconded. Any further discussion? All in favor, signify by raising your hand. It's unanimous, unanimously approved. And then I think we can move on to the question of adopting the scheduling order with the dates we've decided on for motions to be included in that scheduling order, as well as the change in the hearing date itself. I'll make that motion, and I'll look for a second.
Second?
It's been moved and seconded to, yes. Attorney Larson?
The other date that should be changed is the date that the board meets to rule on the motions, which will be not,
It's the 7th from 4:30 to 5:45, is that correct?
yes.
Yep, so I have that.
To rule on the motion, Paul, it says August 8th, it'll be August 7th instead.
Let's roll on the motions.
Yeah, instead of August 8th, it's August 7th, and then we've got the August 22nd for the other motion.
Any time on August 20th.
August 25th, I
25th,
believe.
not the 22nd.
Cody, did you say that?
Oh, yeah, August 25th at what time did we say on August 25th?
I don't think we actually set a time yet.
We better do that.
I had written down 4 p.m.
I had it 4
Oh,
p.m.
okay.
4 p.m.?
Thank you.
Is that 4 p.m.?
4 p.m.
4 p.m., okay.
August
August
5th.
25th.
4 p.m.
4 p.m., August 25th for that second motion hearing. The first is August 7th at 4:30.
August 5th is what's the,
Can we get a copy of the scheduling order once it's finalized in our city emails as well?
Yes, that would certainly be very helpful.
so August 5th, what is this date? And what's what are we doing then? I'm really confused.
Okay, on August 7th, we're having that hearing on, or not hearing, but we're having a meeting to rule on the motion to compel, the respondent's motion to compel depositions. So August 7th at 4:30.
Right, okay.
And then, on the other end of this time frame, we're looking at August 25th at 4 p.m. to rule on any pretrial motions.
Okay. I'm going to get this.
And we also want the, and not pretrial, pre-hearing motions.
Pre-hearing, thank you.
That was the other thing. Okay, and
August 25th, pre-hearing, we don't have a time yet, right?
That was 4
to 5
o'clock.
that's
p.m.
4
4
o'clock.
p.m.,
4
yes.
p.m.
And then we have the hearing slated for
August
September
7th
5th.
is the rule on
On the motion to compel.
motion to compel. Well, that's news to me. All right. And then we go down to, what was it, August 25th or?
Yes. August 25th at 4 p.m.
This is the
on pre-hearing motions.
pre-hearing motions, okay. 4 p.m. I don't get lost. Holy cow. August 5th. compel.
And
5th. We have a time for that. It's 4:30. 4:55.
25th is at 4 PM.
25th, yeah, but we're August 7th too. Don't you have that?
August 7th is at 4:30, yes.
4:30, and that is to,
That's on the motion to compel.
oh, I thought that was the 5th. What's the 5th for?
No. We don't have anything. Well, September 5th is going to be the hearing.
Their
So we
Yeah.
cut out August 5th.
August 5th was their reply is due.
No longer.
That's not us. Like, that's
Now August 7th.
just for the replies we're due.
All right, I think we need to make sure we know who's going to be drafting that. Or will Attorney Larson, will you draft that revised, or draft?
I'll have it for you momentarily if you want to wait. I could screen share it if it seems. But I think it's reasonably clear at this point.
And I will also make a Outlook calendar invite for everyone and include everyone on that.
Right, but I think we need to have a final copy of the scheduling order that all members can get in their email, so they can refer to it as needed. So, Attorney Larson, would you like to provide that to the board members or to Cody, who can then provide it to the board members? And does it need to be signed?
So I will send it to you, Calvin, just to make sure that you, as the chair, agree that I have it correct. And if you agree, then you should sign it and get it to Cody, and Cody can distribute it.
Great, thank you. All right,
Then, Mr. Chairman, if I may,
yes.
if this scheduling order is going to be based on Mr. Larson's email, which is the product of our phone conversation with counsel for Ms. Bernardi and Attorney Jacobson, there was a discovery cutoff of August 20th that was baked into that email that we had discussed at the time, with the understanding that the hearing was going to be a go on the 25th. In light of Cody's comments about the Wisconsin Clerks Conference running from the 18th to the 22nd, if we don't have a hearing on the motion to compel until August 7th, assuming it's granted, that only leaves about 6 business days to get Ms. Bernardi's deposition done. Well, actually, if it's the 20th, it leaves, I mean, if she's not there, I mean, it leaves really the week of the 11th. And so I propose that the discovery cutoff be moved to either August 28th or 29th, just to give her some breathing room to the extent that she needs to give a deposition, but it's gone the week of the 18th.
I am also going to throw a complication in there. Clerk Bernardi will be out probably those 2 weeks prior. Her child is having surgery.
So then we can move that to, what, the 28th would be the Thursday after? Would that be?
Well, then let's move it to September 3rd. I mean, if she's going to just be out of pocket.
Well, she's going to be gone before that, not after that. So she'll be back on the 22nd, and that would give her 4 days, 5 days to complete the deposition that week when she gets back.
Oh, she'd be around the 25th?
I believe the 25th is that's when they'll return to work, if I'm not mistaken.
Yeah, and if we just move the discovery cutoff to like the 29th, we should be able to fit her in.
Perfect.
Cody, can you confirm, is that going to work? Would that work?
I believe so.
Okay, I'm getting lost in.
So the discovery
Let's do.
discovery cutoff August 20th. That's what we're going to say.
29?
Sorry, 29th.
Yeah.
29th.
That works for you, Attorney Larson?
Discovery.
Yes.
All right. Any objection by any of the board members?
No objection.
Not hearing any.
None.
All right, I'll look forward to receiving that final draft of the order from Attorney Larson. Okay. So, Robin, have we voted on any of the motions we talked about that we're going to need? I don't.
Well, we just needed I don't know if we need a motion on any of this scheduling, unless we need a motion on the scheduling order
I
itself.
think we do, yes.
Okay.
So
Is there,
what's our next meeting? I'm trying to think. Because I keep moving between the August 5th and the 7th.
So
Pretty
7?
confused.
do we, perhaps Attorney Larson could share that with us? Do you want to share that screen? Do you have it that you could share that?
I have it. I'm just going to share it.
Yeah.
I think I can.
Motion to bill. That's at 4:30 to compel. Motion 7th.
I think we saw it for a second.
Sorry. I can't get back to it for some reason. It's not letting me. Letting me share a lot of things, but it's not letting me share the right thing. So I'm not sure why that is.
I'm sorry, I still didn't like it. Or my hearing must be going.
Right. If I enlarge that, can you see that?
Yep.
Yep.
Motion to compel.
So
That is set at August 7th, right?
I'm going to scroll down. This was the first change we put in August 7th at 4:30. The next change was here, August 25th at 4 o'clock. We're going to rule on the motions. Hearing will be on September 5th at 10. Discovery must be completed on or before August 29.
That is correct from what I have.
Well, I would move to adopt the scheduling order as it's been presented to us by Attorney Larson.
I'll second that if you will take a friendly amendment to change pretrial to pre-hearing. Will you accept that?
I would accept that.
All right, thank you.
Very friendly.
It's been moved and seconded. Any further discussion on this? All right, we'll call it to a vote. All those in favor of adopting the scheduling order as we're viewing it right now, raise your hand. The motion passes unanimously. All right, I think we're ready to move on to the next item on the agenda, discussion of and possible action on other matters discussed by board counsel with other counsel regarding the pending complaint filed against Mayor Doug Denny. One of the items that comes up is that respondents' counsel requested to be included in all communications concerning ethics board meeting dates. I can't imagine that anyone on the board would object to that. It certainly seems necessary And I think we will, if you want to vote on that, we can, but otherwise, as long as Cody's got no problem with it, we would ask him to make sure that that takes place. That's sufficient to deal with that matter? Then there is an item mentioned that Respondents' Counsel would consider proposed stipulated facts, but he will not draft them. And there's been a little more said about that. Well, maybe not about the stipulated facts, but I would, the agenda has, the next item on the agenda deals with that subject, so we don't need to talk about it right at this moment. The role of the complainants is a topic that Attorney Erlinson spent a little time talking about just a few minutes ago, and his expectation that the complainants must be present at the hearing to present their evidence and testimony. In fact, I think Attorney Erlinson used the term prosecute their case. I note that nothing in the ordinance expressly requires the complainants to be present at the hearing or to present evidence or testimony, and certainly not to prosecute the case. I do have some concerns about the possible chilling effect on the enforcement of the ethics standards if a complainant or complainants are expected to be required to attend a hearing and prove a case when the ordinance is designed to require only a proper complaint, which is then investigated by the board. So that's all that's required of the complainants. Many citizens may be reluctant to file ethics complaints, legitimate ethics complaints, for fear of having to hire an attorney. Nevertheless, the ordinance gives the respondent due process protections, which is certainly an important public policy reflected in the ethics code. So when we make our decisions about subpoenas, I think, I'm giving my feelings in advance, but I think it would be important to subpoena the complainants to be present at the hearing and to be available to testify regarding their role in this process. Thoughts from other board members on this topic at this time?
So you talked about subpoenaing
The complainants.
complainants.
I guess I would, I would struggle with subpoenaing the complainants only because of the reasoning that you put forward initially, saying that if individuals want to submit a complaint to the city and then have the board, which is the deliberative body, just discuss it and then move forward or not, I feel like they've offered their testimony, they've offered their complaint. It may muddy the waters to have them come and try to further that complaint, and I think it would possibly convolute our process, because at this point we're taking the complaint at base value, not expanding, not contracting, taking it at what it is in order to understand what our ruling will be. And I think the more that we add to that, the more complicated the conversation becomes, the less likely we are to actually answer the initial complaint.
I would
Yes,
think
Doug.
that in terms of, it's pretty obvious, there's the requirements when you making a complaint do endanger you, they put you in position of possible perjury. So a lot of times that does limit the number of complaints we have. We tend to have not a lot of complaints, but it's there, I think, to exclude harassment complaints. So I think there already is something that actually slows down people from coming. I'm not against that. Fewer complaints might be better, as far as I'm concerned. But I don't think the additional, what you said earlier struck home with me, that they might have to come and get legal representation themselves seems a little extreme. That would lead to no complaints.
I'm wondering if we could, we were going to discuss subpoenas at the next meeting that we have. I'm wondering if we could do that. I would like to review the ordinance again myself.
Sure.
I do appreciate the comments you said at the beginning about whether that would make people more fearful of, making complaints if then they get called. My one thought is that we could subpoena them, ask them if they have anything to add or anything that they would have, but then let them off of the subpoena after they provide any additional information, that we wouldn't force them to stay during the entire matter. But I want to think about, I
Right.
really do want to think about that a little bit more.
Right, and we could think about what would be the proper scope of examination of them as witnesses. What is their role in the process? Do we really want to allow them to be grilled about anything that might come to mind, or should we be limiting the scope of examination of the witnesses? I don't know. I just think we need to start thinking about it. I'm not saying that, even my feelings are hard and fast on it, but I do see some kind of competing policies there. The other thing I wanted to mention, Doug brought up the possibility of, of provisions in the code that might work to help prevent harassment type complaints being filed. And I do note at the very end of the code, there is a provision that says that if the board finds that such a complaint was brought just to harass or for malicious purposes, that we can require the party that brought such a complaint, besides dismissing the complaint without probable cause, for example, we can decide that the person that brought the complaint shall be liable for the costs of the proceedings as well as the respondent's reasonable attorney fees. So there are some pretty strong safeguards against that kind of thing happening. And it's important to keep that in mind along with everything else, I think.
It seems that the restrictions apply when I think the city attorney's office. That is, when you're making a complaint, you have to have an affidavit, you have to sign, and I think that isn't in our code, as far as I know. It's not in the code, but it's what's used.
Well, it's in the code that a verified complaint is required, and
Right.
that's where the...
Right. But I just know we can, as a body, investigate anything that we become aware of as a possible ethics. I remember, reading that in the code, and so that's where
Is that still in the code?
I believe it is.
Well, that's something we can...
But I would like to review that.
Yeah. Yeah.
I would also like to add that I think the complainants aren't necessarily witnesses, and I think that this hearing is for witness testimony and discourse on those individuals that had seen this take place or at least had a peripheral experience with it. I don't know that the complainants actually had any of that. I think their complaint comes from evidence that, they had heard. So I don't know that their testimony would actually be a benefit when compared to the other testimonies that we're talking about gaining information from actual individuals who had engaged with anyone or anything having to do with the case.
Yeah, that's something to keep in mind as well. I mainly wanted to just stay on course with the idea that, let's look at what the code says. Mm-hmm. What does the code actually require of complainants? I see nothing in the code indicating that the complainants are supposed to prosecute the case against the respondent. So, I want to avoid us going off on the wrong track. But let's give it some thought. Let's look at the code again. Mm-hmm. Keep in mind the due process protections. Mm-hmm. They're very important. Yep. But also important is the policy that we don't want to dissuade people from making ethics complaints because they're afraid of what they're going to get into. I don't think the code is designed to make it an onerous procedure for complainants to have to worry about hiring an attorney to defend them from attacks if they file a complaint against somebody. Because let's face it, emotions can get heated on these things, and so we have to look at the policies. We have to look at what the code actually says and try and be faithful to that. All right, anything else?
I'd be interested in what I just assumed goes on, which is that, if I make a complaint, I have to come and make an affidavit. I have to sign that off, and that is a restriction. But I don't think that is stated in the code. Mm-hmm. I think it's just a practice. So we might want something, we might want to elevate it to the code say it's part of the code that all complainants must do such and such to even make a complaint, and then we decide if there's probable cause.
And we could visit that procedural change, but I think it's not relevant necessarily to
Right.
this hearing, right?
Right. Yeah.
Okay. All right. Well,
Okay.
It's been very interesting.
Yes.
So Attorney Errolson, that's been very interesting addition to our concerns. Thank you.
The next item on the agenda is discussion of and possible action on authorizing the Ethics Board's legal counsel to seek an agreement with complainants and respondent on a stipulation of facts relating to the complaint filed against Mayor Doug Dinny. I would move to authorize the board's counsel to draft, propose, and negotiate with complainants, respondents, legal counsel, and I believe also counsel for unelected city officials, a statement of uncontested facts. We clear on what the motion is? I mean, we want to authorize the board's legal counsel, Attorney Larson, to pursue a stipulation of uncontested facts. If we can have agreed facts, we don't have to have testimony about them. And it seems to me that our investigation didn't uncover much disagreement between those responding to our investigative orders about what happened. It's not so much a question of what happened. It's a question of what was required, what did the law require, things like that. So there should be a lot of room for agreement on what happened. I mean, a lot of the facts that have been provided to us come from the respondent, and haven't been, I haven't seen a dispute over them. So it seems worth doing, and it seems like it could make things more efficient for us. And I'd like to at least see us try to accomplish something along those lines. So that's the purpose of my motion, and I'll ask if there is a second.
No, the motion is to what?
The motion is to authorize the board's
Authorize,
counsel.
But the council does not have to do it. It's just we authorize the council if that's what the council is willing to do.
Yeah, he's already started talking with them about it,
Okay.
with the other council.
Because I don't want to sort of make the council do that. Just don't want, it's okay if you want to do that.
So it's my understanding this is meant to more or less bridge a set of facts that can be agreed upon by all parties involved as a given. So that we then, if we get to the hearing, those are uncontested facts. We agree that this is true, and the things that we don't agree about, then we can discuss further.
Correct.
And that's the point of this. Yeah, I mean, I'm in agreement with that. I would
Correct.
definitely
yes.
hasten the process.
Seconding.
I would second, yes.
Thank you. It's been moved and seconded. And yes, Doug, the motion is to authorize,
Authorize,
not
just-
to
Yeah,
require.
so just for discussion, I have a little bit of hesitancy in that. And it's coming from just giving some of our powers of deciding what the facts are over, and I don't know what those are yet. And so I'm having a little bit of a struggle just with a blanket authorization. I don't know if there's a way that that can be negotiated and discussed and be brought back to us for our review before it is stipulated by the parties.
Well, good. That's a good point, Robin, and I think maybe we could just add to this, subject to board approval. So we're authorizing the board's counsel to draft, propose, and negotiate with the complainants, respondents, and legal counsel, respondents' legal counsel, and counsel for unelected city officials, subject to board approval, a statement of uncontested facts, or put the subject to board approval at the end. I think that,
Yeah,
not
that
gonna
would
be-
make me feel better. It's just really hard to just do this blanket authorization that no offense to Attorney Larson.
or to any of the attorneys.
Yeah.
It's a valid point, Robin. for sure.
But I would like to have some sort of approval of that.
Certainly, I think that's a very good point, and I don't see any problem with doing that. Any other discussion?
Is that an amendment to the motion then?
Oh, yeah, good point. Thank you. Thanks again for watching that. Yes, that would be an amendment to the
And I would
proposal.
second the amendment to the proposal. Do we have to vote on it twice then?
Movers approval?
Why don't we, if we're both okay with it, we'll call that a friendly amendment to add
Okay.
those words at the end of the existing motion.
Okay. Are you
And
okay?
do you want me to read it
Second.
again?
Absolutely, yeah, yeah.
Yes.
Anybody want, okay, I'll read it again with the addition. Motion to authorize the board's counsel to draft, propose, and negotiate with the complainants, respondents, legal counsel, and counsel for unelected city officials a statement of uncontested facts, subject to board approval. Okay? I would like to ask if Attorney Larson has any reaction to that. Does that sound all right to you, or do you have any advice about anything else?
I mean, it's fine. I do my best. I don't know that. We'll see what happens.
Yeah.
I
Right.
don't know that we'll succeed.
Right.
And I am not sure that the unelected officials will want to participate in this. So, and I'm not sure what their role would be. At most, they're witnesses. So I don't know why be stipulating to anything.
Right, and nobody can be, they can't be compelled to participate, and certainly no one can be compelled to agree.
What exact? And the way I think about it is that if there was, even if Attorney Larson and Erlander were able to agree, it doesn't have to be all three. I mean, it's just if there were some stipulated facts between two of you, it would be nice to know about that and be able to approve of that before the hearing.
Sure,
Just to limit what those facts are.
yeah,
But whether or not it's successful, I think it's
who knows? It just seems worth trying
sure.
to me. All right, thank you. Well, we've got a motion. We've had some discussion on it. It's been seconded and revised with a friendly amendment. All those in favor of adopting the motion signify by raising your hand. That also is approved unanimously. All right. Any other comments other members of the board would like to make at this time before we conclude? No other business to come before the board? Seeing none, the chair will entertain a motion to adjourn this meeting.
I so moved.
It's been moved by Doug Hostler. Is there a second? Second by Jesse. All those in favor signify by raising your hand.
Aye.
It's another unanimous approval. Thank you all, and we'll see you soon.
Thanks.
Thank you.
Thanks to the attorneys, yes.
We got the date straight. So August 7th, 4:30 to 5:00. The motion to compel. I appreciate your
Right, our ruling on the motion to compel.
I had a little bit.
hearing motions considered.
I was just like, I don't want to give all my
Yeah.
power away.
That's August 25th.
Right.
I don't